This case concerns a road traffic accident involving the plaintiff, Nur Aisyah binti Rahman, and a delivery lorry owned by Factual Logistics Berhad. The accident occurred at a signalized pedestrian crossing near Jalan Tun Razak, Kuala Lumpur.
I am on my day off and going to the bus stop. The signal is green. It is safe for me to cross.
The driver failed to stop and struck the plaintiff while she was crossing legally.
The lorry was traveling fast and the driver was looking at his phone and the driver was running at the red light.
Ah! My leg hurts! Someone! Help me!
Further investigation revealed that the driver had not attended mandatory safety training for 2 years.
I suffer fractures in my right leg. I underwent surgery and physiotherapy. I was unable to work for 6 months, and I continued to experience pain and anxiety when crossing roads.
The plaintiff incurred medical expenses, rehabilitation costs, and loss of earnings.
Please be seated. This is the Session Court of Kuala Lumpur. This is Silver Suit number WA123 NCVC 45605 2026. The matter before this court is the claim of Nur Aisyah binti Rahman against Factual Logistics Berhad. Counsel for the plaintiff, you may proceed with your submission.
May it please, Your Honor. Thank you. I am Daniel Ashrafan bin Muhammad Shamsulhan, and I appear on behalf of the plaintiff Nur Aisyah binti Rahman. The plaintiff brings this action against the defendant Factual Logistics Berhad for personal injury suffered as a result of the negligence of the defendant's employee Muhammad Hafiz bin Saleh. Your Honor, this is a claim for negligence arising from a road traffic accident that occurred on the 15th of March 2025 at approximately 3:30 p.m. near the intersection of Jalan Tun Razak, Kuala Lumpur. The plaintiff was lawfully crossing the road at a pedestrian crossing when the defendant's lorry, driven by his employee, ran a red light, struck the plaintiff, and caused her serious injuries. The plaintiff submits that the defendant is vigorously liable for the negligence of his employee. We will now present our submissions on the issues for determination.
Counsel may proceed.
Your Honor, there are 4 issues for determination in this case. The first issue is whether the defendant owed a duty of care to the plaintiff. The second issue is whether the defendant breached that duty of care through the action of his employee. The third issue is whether the breach caused the plaintiff injuries. The fourth issue is whether the plaintiff is entitled to damages. Your Honor, I will now address each issue in turn. Your Honor, on the first issue, we submit that the defendant owed a duty of care to the plaintiff. The law on duty of care is well established in English common law. In Donahue v. Stevenson, Lord Atkin laid down the neighbor principle. Lord Atkin stated that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Lord Atkin further explained that one's neighbor is any person who is so closely and directly affected by your act that you ought reasonably to have them in contemplation when directing your mind to the act or omissions in question. In this case, the defendant's employee, Muhammad Hafiz bin Saleh, was driving a delivery lorry on a public road. As a road user, he owed a duty to other road users, including pedestrians, to exercise reasonable care. The plaintiff was a pedestrian crossing at a designated pedestrian crossing, and she was directly affected by the employee's driving. Therefore, she was his neighbor within the meaning of Donahue v. Stevenson. Furthermore, the modern 3-stage test from Kaparo Industry v. Blakeman confirms that the duty of care exists when 3 conditions are met. First one is, the damage must be reasonably foreseeable. Second, there must be a relationship of proximity between the parties. Third, it must be fair, just, and reasonable to impose the duty. Applying these tests to the facts, the damage to the plaintiff was entirely foreseeable. A pedestrian being struck by a heavy lorry at a pedestrian crossing is a foreseeable risk. There was proximity between the parties as they were both on the public road. It is fair, just, and reasonable to impose a duty on drivers to exercise care towards pedestrians, Your Honor. I submit that the defendant's employee owed the duty of care to the plaintiff, and therefore the defendant is liable for the breach of that duty.
Proceed, counsel.
Your Honor, on the second issue, we submit that the defendant's employee breached his duty of care. The test for breach of duty was established in Leeds and Birmingham Waterworks Code, where the court held that negligence is the omission to do something which a reasonable person would do, or doing something which a reasonable person would not do. The standard is objective. We ask what a reasonable person would have done in the same circumstances. Your Honor, the defendant's employee failed to act as a reasonable driver would have done so. The evidence shows multiple instances of negligence. First, he drove a lorry at excessive speed. The lorry was traveling at approximately 70 kilometers per hour in a 50 kilometer per hour zone. A reasonable driver would not speed. Second, he used a mobile phone while driving. Witnesses and CCTV footage confirmed that the driver was looking at his phone directly and shortly before the collision. A reasonable driver would not be distracted by a mobile phone while operating a heavy vehicle. Third, he failed to obey a red traffic light. The driver ran a red light while the plaintiff was lawfully crossing the road at a red light. Fourth, he failed to keep a proper lookout. He did not see the plaintiff despite her being at the designated pedestrian crossing. A reasonable driver would keep on a proper lookout at all times. Fifth, he failed to brake in time to avoid the collision. Skid marks at the scene indicate a late attempt to stop. A reasonable driver would have stopped at the red light before the collisions occurred. Your Honor, these facts clearly establishes a breach of duty. The driver failed to exercise the standard duty of care expected of a reasonable person. Furthermore, subsequent investigation revealed that the driver had not attended any defensive driving or safety refresher training for 2 years. The defendant had a company policy requiring periodic safety training for drivers, but this policy was not enforced. This failure contributed to the driver's negligent conduct. Your Honor, I submit that the defendant's employee breached his duty of care.
Thank you, counsel. I note the submission on breach. Please proceed.
Your Honor, on the third issue, we submit that the breach of duty caused the plaintiff's injuries. The test for causation is the but-for test, established in Barnett and Chelsea and Kensington Hospital Management Committee. The question is, but for the defendant's negligence, would the plaintiff have suffered her injuries? If the answer is no, then causation is established. Applying this test to the facts, but for the driver running the red light, the plaintiff would not have been struck. But for the driver speeding, the impact would not have been so severe. But for the driver using his mobile phone, he would have seen the plaintiff crossing the road. But for the driver failing to keep a proper lookout, he would have braked in time. The evidence confirmed causation. The plaintiff was lawfully crossing the road with a pedestrian green signal. She did nothing wrong. The only cause of the accident was the negligence of the defendant's employee. The breach directly caused the plaintiff's injuries, Your Honor. I submit that the element of causation has been satisfied. Your Honor, on the issue of remoteness, we submit that the plaintiff's injury was not too remote. The test for remoteness is found in the wagon mount case, where the court held that the damage must be of a kind that is reasonably foreseeable. If the damage is reasonably foreseeable, it is not too remote. Applying this test to the facts, the plaintiff suffered a fractured right tibia and fibula, soft tissue injuries, head injury, and psychological trauma. These injuries are entirely foreseeable consequences of being struck by a heavy delivery lorry at speed. The size, weight, and momentum of the commercial delivery lorry made the risk of a serious injury obvious. Any reasonable person would foresee that a pedestrian hit by such a vehicle would have suffered serious injuries. Your Honor, I submit that the plaintiff's injuries were not too remote, they are directly linked to the defendant's negligence. Your Honor, I also submit that the defendant is vigorously liable for the negligent act of his employee. The principle of vigorous liability was established in the case of Lister and Henry Hall, Limited, 2001, where the case states that an employer is liable for the wrongful acts of an employee committed in the course of employment. The employer is responsible even if the employee itself did nothing wrong. The liability arises because the employee was acting on behalf of the employer. Applying this to the facts, Muhammad Hafiz bin Saleh was employed by the defendant as a delivery driver. At the time of the accident, he was driving a company lorry during working hours and performing delivery duties assigned by the defendant. He was acting in the course of his employment. Furthermore, the vehicle he was driving was owned by the defendant and was being used for the defendant's business purposes. He was on the job when the accident occurred. Your Honor, the defendant cannot escape liability by blaming the driver alone. The employer is responsible for the negligence of his employee committed in the course of employment. Additionally, the defendant failed to ensure that its driver attended mandatory safety training. The driver had not attended defensive driving training for 2 years, despite company policy requiring it. This failure is itself evidence of negligence of the employer. Your Honor, I submit that the defendant is vigorously liable for the negligence of his employee.
Proceed.
Your Honor, on the fourth issue, we submit that the plaintiff is entitled to both general and special damages. First, I address general damages. General damages compensate for non-financial losses, including pain and suffering, loss of future earnings, and loss of amenities. Your Honor, the plaintiff suffered a severe fracture of her right tibia and fibula. She underwent open reduction and internal fixation surgery requiring metal plates and screws. She was hospitalized for 14 days. She underwent extensive physiotherapy and rehabilitation. She also suffered psychological trauma, including anxiety and a constant fear of crossing roads. Based on nomination case precedents, including Rahim and Wee 2019, which awarded the total of Rm 45,000 ringgit for similar leg fractures requiring surgery, we submit that Rm 55,000 ringgit is a fair award for pain and suffering. This takes into account the severity of the fracture, the surgery required, the psychological impact, and the ongoing pain. Your Honor, the plaintiff was earning Rm 2,800 ringgit per month as a pharmacy assistant. She was unable to work for 6 months and lost a total of Rm 16,800 ringgit in income. However, her future earning capacity has also been affected. She has an 8% residual disability to her right leg. She experiences pain and stiffness when standing or walking for long periods. Her job requires extended walking and standing. Her ability to continue in her current role is uncertain. The plaintiff is 30 years old, retirement age is 60. She has 30 years working years remaining. The appropriate multiplier for a 30-year-old is 14. Her annual income is the total of 33,600 ringgit. Deducting 1/3 for personal expenses, the multiplicand is 22,400 ringgit. The calculation for loss of future earnings is multiplicand multiplied by the multiplier, which is Rm 22,400 ringgit, multiplied by 14, resulting in Rm 313,600 ringgit. Your Honor, we submit that the total of Rm 313,600 ringgit is fair award for loss of future earnings. Your Honor, the plaintiff also claims for loss of amenities. Prior to the accident, she was able to care independently for her children and regularly participate in recreational jogging and outdoor activities. After the accident, she has significant difficulty coping at home. She cannot play with her children, she cannot jog or participate in outdoor activities. Her enjoyment of life has been significantly diminished. Based on Malaysian case precedents including Sheikh Alwi bin Sheikh Aziz and Zainal bin Abidin, which awarded a total of Rm 25,000 ringgit for similar loss of amenities, we submit that the total of Rm 25,000 ringgit is a fair award. Your Honor, the total general damages claimed are Rm 55,000 ringgit for pain and suffering, Rm 313,600 ringgit for loss of future earnings, and a total of Rm 25,000 ringgit for loss of amenities. The total general damages amount to the total of Rm 393,600 ringgit. Your Honor, I submit that these amounts are reasonable and justified based on the severity of the plaintiff injuries and relevant case precedents. Your Honor, the plaintiff is also entitled to special damages, where special damages are actual financial losses that can be specifically calculated and proven. They must be pleaded with particularity. The plaintiff has suffered the following special financial losses. For medical expenses, the plaintiff incurred a total of Rm 300 for ambulance fees, Rm 1,500 ringgit for emergency room treatment, Rm 7,000 ringgit for hospitalization at 500 ringgit per day for 14 days, Rm 25,000 ringgit for surgery, Rm 4,500 ringgit for physiotherapy and rehabilitation, and 2,000 ringgit for medication and follow-up consultation. The total medical expenses amount to 40,300 ringgit. For transportation expenses, the plaintiff incurred Rm 1,500 ringgit for 30 trips to and from hospital at 50 ringgit per trip, and 900 ringgit for family members travel at 30 ringgit per trip for 30 trips. The total transportation expenses amount to 2,400 ringgit. For loss of income, the plaintiff was unable to work for 6 months during recovery. Her monthly salary was Rm 2,800 ringgit. The total lost income is Rm 16,800 ringgit. For damaged property, the plaintiff's mobile phone was destroyed in the accident, costing Rm 800 ringgit, and her prescription glasses were damaged, costing another Rm 200 ringgit. The total property damage is amount to 1,000 ringgit. For other expenses, the plaintiff incurred a total of 1,500 ringgit for domestic help during recovery at 500 ringgit per month for 3 months, and 800 ringgit for medical equipment including crutches and wheelchair. The total other expenses amount to 2,300 ringgit. Your Honor, the total special damages claim are 62,800 ringgit. All these losses were directly caused by the defendant's negligence. They are supported by receipts and documented evidence in the plaintiff bundle of documents. We submit that the plaintiff is entitled to special damages in amount of 62,800 ringgit. Your Honor, before I conclude, I wish to summarize the plaintiff case. First, the defendant's employee owed the duty of care to the plaintiff. This duty is established in O'Neill Stevenson and confirmed by the 3-stage test in Couple of Dickman. Second, the employee breached that duty. He drove at excessive speed, used a mobile phone, failed to obey a red light, failed to keep a proper lookout, and failed to brake in time. The test from Lead and Birmingham Waterworks confirms that this conduct fails below the standard of a reasonable person. Third, the breach caused by the plaintiff injuries. The but-for test from Barnett and Chelsea confirms that the accident would not have occurred. Fourth, the plaintiff's injuries were not remote. Under the case of the wagon mount, the injuries were entirely foreseeable. Fifth, the defendant is vigorously liable for the negligence of his employee. Under Lister and Helsley Hall Limited, the employee is liable for the acts of his employee committed in the course of employment. Sixth, the plaintiff has suffered significant losses. She has suffered general damages of Rm 393,600 ringgit for pain and suffering, loss of future earnings, and loss of amenities. She has suffered special damages of total of Rm 62,800 ringgit for medical expenses, transportation, lost income, damaged property, and other expenses. The total claim is Rm 456,400 ringgit. Your Honor, the plaintiff humbly prays that this honorable court grants special damages in the amount of 62,800 ringgit, general damages in the amount of 393,600 ringgit, and interest at 5% per annum on special damages from the date of the accident to the date of full settlement, interest at 5% per annum on general damages from the date of the rate to the date of full settlement, cost of the action, and such other relief as this honorable court deems fit. Your Honor, we have established that all elements of negligence have been satisfied. The evidence support that the plaintiff claimed the defendant is liable for the injuries suffered by the plaintiff. Justice requires that the plaintiff be fully compensated for her loss. Much obliged, my Lord.
I have heard your submissions. I will consider the evidence and the law. The court will deliver its decision at a later date. Counsel, you may be seated. Court is adjourned.